Hello, everyone, and welcome to this podcast edition of the Thomas Jefferson Hour. This week, I interviewed my friend Beau Breslin of Skidmore College about the infamous case Marbury V Madison. I love my conversations with Beau Breslin. He's a big fan of the program, and we often have some of the most spirited conversations here on the Thomas Jefferson Hour. I want to thank all of you for listening. This is a really important case, and it led to the doctrine of judicial review, which, is now central to American life. If you take the Dobbs decision on overturning Roe v. Wade, for example, these 9 unelected, unaccountable, unimpeachable, often conflicted members of the court make decisions that affect a whole nation of 1/3 of a billion people. So that doctrine that the Supreme Court can strike down a provision of a law or strike down a law entirely, that was not written into the original Constitution. That's something that was installed in 1803 by John Marshall. It wasn't without precedent in English and American thinking, but it wasn't in the Constitution itself. And Marshall's cleverness in the decision is one of the most famous moments in Supreme Court history. But we also talk about the personal relations between Jefferson and John Marshall, which were always icy at best and mutually suspicious in most instances. I'm just back from a long journey in the American Southwest for Listening to America. So we're headed that way, as you know, and we had the most extraordinary time for 9 days in Canyon Country. We were on the Hopi Indian Reservation, on the Navajo Indian Reservation, on the Ute Indian Reservation. We went to Lake Powell. We floated on Lake Powell, which I had never done before. We looked down at the Colorado River from a range of different canyon heights. We went to Four Corners, one of the most Jeffersonian places in America. Let me make quickly the case for that. So Jefferson wanted square states, identical in size, and he realized that the first 13 were a done deal. They couldn't be fixed. So he thought, well, beyond the Appalachians, we'll make as many square, identical-sized states as we possibly can. He didn't quite get his way, but if you look at a map, as you go farther west, it gets more rectilinear, more Jeffersonian. When you get to states like Colorado and Wyoming, which are rectangles, or Utah and Arizona, which have lots of strong linear elements to them. Four Corners, where the 4 states come together, is arguably the most Jeffersonian place in America. I've never been. I've always wanted to go. I've seen it in films, of course, including the remake of the National Lampoon Vacation film. And so I talked my 2 very reluctant companions into going there, and it turned out to be great and hilarious. So you'll be hearing more about that. Go to our new website, ltamerica.org, ltamerica.org. Our newsletter is about to be up and running. It's going to be a great new era of this program, which is morphing to the new name, Listening to America with Clay Jenkinson. I couldn't be more excited about this. This was a trip of a lifetime, and more are coming, so watch for that. But as we close this podcast introduction to today's program, I just want to play a little more of my conversation with Beau Breslin. We actually recorded that before we sat down for the formal Jefferson Hour recording, and he was very interesting on these questions. So I'm just going to end with that. Meanwhile, you can contribute if you have an Airstream, if you know somebody who has an Airstream, if you know somebody who knows somebody who has an Airstream. I want one, I need one, because this is going to allow me to follow John Steinbeck's 1960 Travels with Charlie tour from Long Island all the way up to Maine, across the northern tier of America, down the west coast to Texas, to New Orleans, and back up to New York City, all of that in the year 2024. And so this would be a great gift to the Thomas Jefferson. It doesn't have to be new. It just has to be splendid. Anyway, let's listen to this little piece by Beau Breslin, and then let's go to the show. I can't tell you how excited I am about the future. Thanks for listening. Please tell everyone you know. Hello, everyone, and welcome to this edition of the Thomas Jefferson Hour. Today, I interview my friend Beau Breslin of Skidmore College about the famous early Supreme Court decision, Marbury v. Madison. Welcome, Beau.
Thanks, Clay. Thanks for having me.
I'm glad we're having these periodic conversations. I hope you continue to suggest other topics that we can discuss. I have such great fun when we get a chance to dig in on these things. So, Marbury v. Madison. Every law student, almost immediately in first year, has to face this famous case, February of 1803. And it involves the midnight appointments of John Adams, when Adams was discredited and returning to private life. One of the last things he did, in fact, the day before he left the the presidency was to appoint one William Marbury, among others, to a minor judicial post in Washington, D.C. A couple of dozen people altogether involved, more than 50, I think, altogether. And these were last-minute appointments confirmed by the United States Senate, therefore legally valid, and they were not all actually put into the hands of their intended recipients. And so, number one, I blame John Marshall. The Senate took time to confirm these. Marshall didn't put them into the hands of the people who had been appointed.
Yeah, Marshall thought that the actual delivery of the commissions was inconsequential. Not, he had some regret, and his brother is the one who delivered. There were 42 in all, mostly in the Georgetown and Alexandria areas. James delivers a decent amount, but Marbury is one of those individuals who didn't get the commission. And I always say to my students, Clay, that Marbury is the only real loser in this case. He goes down in history as a party to one of the most famous, if not the most famous, Supreme Court opinion. And Jefferson wins something big, Marshall wins something big, the Federalists win something big, the Republicans win something big, and the only real loser is Marbury in this. One of the ways, and there's so many fascinating parts to this particular case, but a lot of it, as you know, comes from the lead up and all of the political tension that's going on at the time, right? So I say the battle over Marbury is a battle of different political ideals, right? It is one of different personal personalities and personal will, right? Marshall and Jefferson are the primary antagonists here. They were distant cousins, they hated each other. And there's a personal element to it too. It is one of political power. Marshall wants the court to have political power. Jefferson wants to have the court to have less political power. And so the battle is over whether or not the court's going to establish itself as a legitimate or credible institution, co-equal in the words of the framing generation. It's also one about vision, class, and political party, right? The yeoman farmer ideal of Jefferson versus the Federalist ideal that Hamilton and Marshall agreed with. So the clash around Marbury versus Madison, the case itself is fascinating, but it's really the context around it. And then I'll say one more thing, that is Marshall misinterprets a lot of what he's charged with interpreting in order to get the outcome he wants. That's sort of the fascinating story behind Marbury versus Madison, is his deliberate, I think it's deliberate, lots of people do, intentional misinterpreting of Article 3 and the Judiciary Act in order to get the outcome, which was judicial review.
A couple of quick things. William Marbury is otherwise a non-entity, a successful Maryland businessman. He's a loyal Federalist, so he's appointed to this sort of plum job, the last second of the Adams administration. And beyond that, he's a complete cipher. No one cares. He just exists as this straw man, if you want to put it that way, in this famous legal case. So John Marshall is the Secretary of State, soon to become the Chief Justice of the Supreme Court of the United States. And a point that really needs to be made is that however Jefferson and his allies responded to this, John Adams had every constitutional right to fill every vacant office in the United States before leaving on the 4th of March, 1801, right?
He and the Congress had constitutional authority to do exactly what they did.
Now, Jefferson resented this for a couple of reasons. He resented it because he thought it was personally unkind. And remember, when Jefferson leaves office on the 4th of March, 1809, even for months before that, he didn't make any major decisions. He wanted to leave as much latitude for his hand-picked successor, James Madison, as possible. He didn't want to in any way hamstring Madison's freedom of action. And so that's typically Jefferson graciousness. Of course, they're best friends. And he felt that he and Adams, as old friends, should have been in harmony on this, that Adams should have realized that he had been sent home after a single term, that the people had effectively rejected him, that they had put somebody else in his place, and that somebody else should have a kind of free hand to surround himself with the kind of people that he liked and would support his policies, and that this was a sort of a personal lack of gentlemanly decorum. And I think Jefferson is to a certain extent right about that. There is a punitive element in what Adams did. He was definitely trying to punish Jefferson to prevent Jefferson's revolution, his Second American Revolution, from being as complete as Jefferson wanted it to be. But from a constitutional point of view, Jefferson's on very thin ground saying that Adams should have refused to appoint any of these vacancies until Jefferson took office.
That's true. And I'll add one more interesting note to it. The law, the Judiciary Act of 1801, that essentially kind of did all of this, included also the reduction of Supreme Court justices from 6 to 5. And in some ways, Jefferson, I think, is absolutely right in being apoplectic about that, because essentially all the Federalists and Adams are doing is removing the possibility of Jefferson from making an appointment. That, to me, strikes me as just as uncivil as appointing the justices of the peace and so on.
Great. So the Judiciary Act of 1801 is just before the transition. Well, the transition is underway, but before the inauguration of Jefferson, and the Federalists decide to do this thing. It sort of smacks of Mitch McConnell a few years ago in the United States Senate. But if then there were 6 members of the Supreme Court. Now there will be 5. So let's say one dies or quits, no appointment. 2 have to go before Jefferson gets 1. In the end, Jefferson wound up appointing 3 people to the Supreme Court. He was disappointed more or less in all of them because they weren't radical enough for Jefferson's idea of the country. But one more thing about all that, Beau, so Jefferson believes that the people are sovereign. And because the people are sovereign, they had every chance of installing John Adams for a second term. They did not. And because of that, he felt that Adams should be listening to that the people have repudiated you. Yes, you're still technically president, but appointments last longer than a presidential term. And so by appointing these people, including Chief Justice John Marshall, you are effectively denying the will of the people, which has spoken to you quite clearly here. And I feel some ideological and intellectual sympathy with that point of view, don't you?
I do. And I think that, we often spend some time, especially on your show, thinking about the transition from Washington to Adams to Jefferson. The juxtaposition of those 3 is they're remarkably different. Adams did not see the world in the way Jefferson did in that regard. I think Washington did, right? So Adams is this puzzling middle piece of the puzzle here between Washington and Jefferson. But yes, I think there's some sympathy for Jefferson's position. The people had spoken, and Adams, literally 2 weeks before he's leaving office, packs the federal judiciary. At best, it was uncivil. At worst, it was egregious behavior.
In the ideal world, Adams would have sat down with his vice president, Thomas Jefferson, and said, look, I probably need to fill these offices. That's my constitutional duty. Let's talk about this. Let's find people that we can equally agree upon that will be good for these minor and major offices. And Jefferson would have then probably said, oh, my dear sir, I trust you. That would have changed everything. But Adams was bitter. He was bitter because the people had turned him out. He was bitter because Jefferson had behaved in some unscrupulous ways during the campaign, or Jefferson's advocates, at least. He was also personally grieving over his son, who died of acute alcoholism during this period. He felt, as he always felt through his whole life, that the American people did not give him the credit he deserved for being the prime figure in the American Revolution. And here was Jefferson, this penman, this visionary, this intellectual voluptuary, who was not Adams. He was not as capable of understanding how a republic works as Adams was. And here was Jefferson defeating him at the polls. And I think that all of those fueled a moment of uncivil behavior by John Adams that Jefferson was offended by. And I'll just close. We have to take a break here in a minute. But then you remember that Jefferson's daughter, Maria, dies in 1804. She had been close to Mrs. Adams for a time. Abigail Adams was really angry with Jefferson for all sorts of reasons by now. And she never wanted to see or talk with him again, frankly. But his daughter dies, and so she says, I can't help but write to you, even though, the ancient affection is over, because I felt so strongly about your daughter. And then Jefferson, instead of just saying thank you, makes one of the big mistakes of his life, and he writes back and says, one thing and one thing only really bothered me about your husband, and that was the midnight appointments, and he should have, blah, blah, blah. So then she really lets him have it, as you know. And so she says, as this act, I am certain, was not intended to give any personal pain or offense, the appointments, I think it a duty to explain it so far as I then knew my husband's views and designs. The Constitution empowers the President to fill up offices as they become vacant. It was in the exercise of this power that appointments were made and characters selected whom Mr. Adams considered as men faithful to the Constitution, and where he personally knew them, such as were capable of fulfilling their duty. This was done by President Washington equally, and she just goes on, just to use the slang term, to tear Jefferson a new one, in a way that almost nobody ever talked to Jefferson. I mean, she was one of the few people who could really let him have it. But she was technically right, but she was wrong from the point of view of how a republic's very delicate harmonies need to operate. And Jefferson was philosophically right, but technically wrong, and made a major mistake by bringing it up in his correspondence with Abigail Adams. So this is really an amazing background to this story. So we'll need to take a short break. When we come back, Beau Breslin of Skidmore College, I want to ask you what Marshall did, because Marshall, in the third and least powerful branch of the United States government, is fighting for the legitimacy and the credibility of the court. But he knows one thing for sure: he cannot get into a fundamental man-to-man controversy with Thomas Jefferson. You're listening to the Thomas Jefferson Hour. We'll be back in just a moment. Welcome back to this special edition of the Thomas Jefferson Hour with one of my favorite guests, Beau Breslin of Skidmore College. We get to do this thanks to Zoom technology. I don't get to your part of the world much, and I know you don't get to mine. I love this. I get to see you. I get to see you in your office with the books behind you and all that academic accoutrement. We're talking about Marbury v. Madison, the famous 1803 Supreme Court case. Certainly one of the top 5 cases in American constitutional history. You think Plessy versus Ferguson, Dred Scott, Brown versus Board of Education, you name them. This one has to be fundamental, right?
Yeah, I think this is probably the most famous. I would put it certainly in the top 5, along with Brown, as you said. I put McCulloch versus Maryland in there. You and I have talked about offline once or twice. The U.S. versus Lopez case in 1995, the guns in school case, I think will have significant ramifications. And so I would put that among the tops, maybe the top 10 most impactful cases in the Supreme Court. But Marbury is the most famous.
And of course, Roe v. Wade and the Dobbs case, Citizens United. There are many, many, many really important cases, but they all hinge on this one. And why? Why do they all hinge?
The simple fact is Marshall establishes for the court the power of judicial review, the ability to refuse to enforce legislation that conflicts or violates the Constitution. And that, at the time, Clay, that power was debated. It wasn't unheard of. It wasn't as if the idea of judicial review or the idea that a branch of government could rule that congressional legislation was unconstitutional, that wasn't unheard of. But there were two sides essentially of the debate. And the one side, largely by Republicans, in part, they were making an assault at this time in the early years of the Jefferson presidency. They're making an assault on the Federalist judiciary as a result of Adams. You see everything from the Virginia and Kentucky resolutions to Jefferson's 1801 message to Congress, where he talks about multiple branches of government having the authority to rule legislation coming out of Congress or the states, for that matter, can be unconstitutional.
A couple of things there, Beau. One is, if you just read the Constitution itself, period, there is no mention of judicial veto or judicial review. That doesn't mean it wasn't in the minds of the Constitution makers. That's another question. But if you're really a strict literalist and you say, where in the Constitution is the concept of judicial review embedded, the answer is not. That's number one, which creates a problem for Jefferson. Jefferson also thought that veto, presidential veto, should only be used for constitutional purposes. So when George Washington was president, he wrote to his Secretary of State, Jefferson, and said, I'm thinking of vetoing a bill. What do you think? And Jefferson said, veto it if you think it's unconstitutional. But if it's just a policy disagreement, you have to let it go. Legislative branch is supreme. If you disagree 100% with the policy, you have to let that stand unless you think there is a principle of constitutional violation here. So he thought maybe this wouldn't have worked, but Jefferson thought there would be at least a tripartite system of constitutional review. Madison was sort of in that camp too for a while. And Jefferson then went farther and said, if the federal government unanimously violates its own procedures, the only answer besides revolution or secession is nullification, that the states will then have to repair the constitutional order because the federal government has gone mad. And so Jefferson has this kind of very diffused idea of this, which I actually think is really an interesting one, but most people are appalled. Marshall says, look, there has to be a final arbiter in a civil society. We're the experts who are set aside for permanent employment outside of the political process to guard the Constitution. And when we think that some provision of some law violates fundamental passages in the Constitution, we have to step forward and say this is unacceptable because we're the guardians of the meaning of this thing, right?
Marshall is taking a stand here. He's taking a position that judiciary will be the branch that oversees and reviews legislation for its constitutionality. You know, it's interesting because spot on, as always, about Jefferson and about Madison. Madison had some, interestingly, Madison had some regret that he couldn't get what he called a council of revision idea through the Constitutional Convention. You know, it's made up of the president and select number of federal judges, this council of revision that could rule laws unconstitutional, but it didn't swim in the convention. At the time, there's just this ongoing debate. It's fascinating because now fast forward, not that long after, but certainly today, nobody would suggest that any of the other branches of government have the authority to rule a law unconstitutional. This is the legacy of Marbury versus Madison, is judicial review. But what's fascinating is Marshall has to thread a needle, because on the one hand, he does not want Jefferson to get away with a lot of the things that he's getting away with. Jefferson makes the argument that it's executive discretion that led him to keep the commissions in the drawer. Marshall says this country is a country of laws, not of men. It's like a little bit of a slap in the face for Jefferson, who's arguing that it's up to him, essentially, whether or not he delivers the commission. Marshall knows that if he rules in favor of Marbury, that Jefferson will ignore the order and the Supreme Court will take many steps back in Marshall's quest to make it a co-equal branch. He knows that if he rules in favor of Marbury, which he desperately wants to do, Jefferson's going to ignore it. He also knows, though, that he can't just let Jefferson win the case. He needs to get something out of it. And judicial review is what he gets out of it. So what's interesting is Marshall sacrifices the ability of the judiciary to get this writ of mandamus from the executive branch, which everybody was nervous about on the Jeffersonian side. He sacrifices that in exchange for getting judicial review in a brilliant masterstroke of judicial statesmanship.
All right, so here's William Marbury, who is getting this job. And the commission he's been appointed by the president, he's been confirmed by the Senate, but his legal document is still sitting on the desk of the Secretary of State. Marbury is upset, of course, as one would be, and he then files under a writ of mandamus, which means hand it over, hand the thing over. Writ of mandamus is embedded in Article 13 of the Judiciary Act of 1789 and says, there it is. It says you have to hand this document over. Jefferson could have done it and just said, okay, but he chooses not to. The case gets to John Marshall, and Marshall knows that if he rebukes the administration that says this thing should have been delivered, Madison should have delivered the commission. So this is an open political attack, but legally based on what Jefferson and Madison have done here. But he also knows, as you say, that if he says, all right, hand it over, there's at least a good chance that Jefferson will say, the court's made its decision. Yeah, go ahead and try to enforce it, because I ain't doing it. Now, I'm not sure 100% that Jefferson wouldn't have handed it over. That's a debate we can have. But Marshall couldn't do that, because if Jefferson just simply shrugged and turned away after the court affirmed that Jefferson should hand over the commission to Marbury, the court loses credibility may become a non-entity. It may become just, have a few original cases on maritime issues and diplomatic issues, and it may be the court of highest appeal, but it no longer can weigh in on fundamental questions of American life. Marshall understood this, that he could lose ground. He's probably not going to gain ground by siding with William Marbury. He then slaps Madison and Jefferson around a little bit in the decision and then says, well, too bad, because Article 13 of the Judiciary Act of 1789 is actually unconstitutional. They should have been more careful in crafting that important enabling legislation, because Article 13 violates the Constitution of the United States, and therefore I can't give William Marbury his relief because that provision of the act was unconstitutional. All right, so he's giving the victory to Jefferson now. You don't have to deliver the commission, right? Do you think that Jefferson and Madison understood what had just happened?
Yes, because the debate around what we now call judicial review, right, the power to refuse to enforce legislation that contradicts the Constitution, that debate had been happening. One of the great stories about the Section 13, Article 13 of the Judiciary Act of 1789, which seemingly gives Marbury opportunity to get the writ of mandamus, that section was written by Oliver Ellsworth, who becomes Chief Justice. So Oliver Ellsworth has to understand that that provision that Marshall eventually says is unconstitutional is not unconstitutional. Oliver Ellsworth has a good legal mind. He becomes Chief Justice of the United States. But yes, I think that Madison and Jefferson understood. They also, though, I think they celebrated the victory, even though they had been, as you say, slapped around a little bit. It's also a victory for the Federalists because Jefferson is embarrassed by Marshall's opinion. Has Marbury a right to the commission he demands? The answer is yes, Marshall says. If he has a right and the right has been violated, it has been violated, do the laws of this country afford him a remedy? Yes, the writ of mandamus is the remedy. If they afford him a remedy, and they do, is it a mandamus issuing from this court? Unfortunately, no. So Jefferson loses on kind of the moral side of it because he's embarrassed by the fact that he violated Marbury's right by not delivering the commission. So the Federalists are all celebrating this moment in which Jefferson is embarrassed. But as I said, Marbury is the real loser in here. Federalists win, Marshall wins, gets judicial review. Jefferson wins, doesn't have to deliver the commission. Marbury is the one loser in this whole.
In our time, Beau, Marbury would go on to have a talk show and he'd write a book. He'd build a career on this, which is what happens today. He just disappears from history. I mean, just absolutely disappears. All we remember is his name. And so, as you say, he's the big loser here. But that was the first instance of judicial review in American constitutional history. The second is Dred Scott, which is decades later. In our time, every spring we wait for the big decisions, and we know that the court can make gigantic changes in American life. That never happened in Jefferson's 2 terms again. It didn't happen in Madison's terms. It didn't happen in Monroe's terms. John Quincy Adams, Andrew Jackson. It doesn't happen until just before the Civil War that a second case of judicial review even occurs. And so, I mean, what do you think that Jefferson would say today when 1/3 of a billion people wait in May and June of every year to see what their destiny is going to be as determined by people like John Roberts and Sonia Sotomayor and Clarence Thomas?
So I think Jefferson would be disturbed at a minimum by
Put it lightly.
by the authority of the Supreme Court. I've always said, certainly in my lifetime, the presidency has erupted in power, but so has the court. And there are lots of reasons for that. The Marbury case is just the first, but the Warren Court kind of took it to a different level. I think Jefferson would be really upset by the oligarchy nature of our political system as a result of the Supreme Court's disproportionate power. It's no longer the least dangerous branch, to quote Publius.
What were John Marshall's motives here? So it's complicated. He doesn't like Jefferson very much. He doesn't like Jefferson's political system, his vision very much. Is he fighting for the legitimacy of the court?
Historians have largely, and political scientists and legal scholars have largely said that Marshall had two goals during his 3+ decades as Chief Justice. He has one of the longest terms as Chief Justice. He has two goals. One is to establish the Supreme Court as a legitimate, credible, and maybe even co-equal branch in the separation of powers in the federal government and the national government. Marbury is the most important case, but not the only case where Marshall establishes the Supreme Court as a co-equal branch. His other one is to establish the national government as supreme over the state. So you see cases like Cohen's versus Virginia, or the most famous is McCulloch versus Maryland, Gibbons versus Ogden. These are all with the vertical distribution of power, federalism. Marshall desperately wanted the federal government, the national government in DC, to be more powerful than the states. And so he has those two goals during his 30+ years. But Marbury is the greatest case to establish the branch as a co-equal.
How clever was Marshall? I mean, I wish we had the correspondence. I wish we had the table talk behind the scenes of him thinking, all right, I don't dare demand that they deliver the writ because Jefferson may ignore it. I can maybe sneak that kind of in here by way of by giving Jefferson a little political victory. Do we know anything about his thinking, his machinations, the way he deliberated? Because this is, I think, one of the handful of cleverest judicial decisions ever.
Well, I think that, so the answer is no. We don't know much about what how he was thinking behind the scenes. In my opinion, it's not one of a handful. It is the single most brilliant strategic move on the part of any Supreme Court justice. A little known fact about Marshall is he gets rid of the seriatim decisions, right, where every justice writes an opinion, and he speaks for the court, right? So in Marbury versus Madison, he's speaking for the court. That is also his kind of strategic way of crafting or navigating what might be very different justices' opinion. Very few people thought Marbury versus Madison was going to be the case that was the explosive case. Stewart versus Laird, which was argued on the same day as Marbury versus Madison, is the case that challenges the constitutionality of Jefferson's Repeal Act, right? The act that repealed the Judiciary Act of 1801. Everybody was nervous about that one. All Jeffersonians were nervous about that one because they thought Marshall and the Supreme Court would argue that the Repeal Act of 1802 would be unconstitutional. But no, one of the brilliant strokes that Marshall does is he embeds judicial review in Marbury versus Madison, a comparatively obscure case. A lot of people think it was a bigger deal now, but it was at the time not the biggest deal. They didn't shut down the court in the 1802 term to avoid Marbury versus Madison. They shut down the court in the 1802 term to avoid Stewart versus Laird. One of the master strokes that he does is he embeds judicial review in Marbury versus Madison as opposed to Stewart versus Laird. So there's just a lot of things that Marshall does that all turned out the right move. His instincts were right, and he, as I said, he navigates this really tough situation where Jefferson's on the one hand breathing down his neck, Federalists on the other, and he navigates it in the most brilliant way to boost up the power of the court.
Jefferson's view is that the Constitution is a restraining document. The powers of government are carefully enumerated by 55 demigods, that if they wanted a national bank, they would have enumerated a national bank, that if you want something that's not enumerated, you have to seek a constitutional enabling amendment. Jefferson surely believed that if judicial review was that important, the Constitution makers would have written it into the article, that they would have said this is what the court must do. But they didn't. And so is Jefferson right?
Not in my opinion, no. And there is a touch of irony here. Madison's argument, Jefferson's argument essentially, is that the president has a certain degree of discretion, and that includes discretion to withhold the commissions. Well, it doesn't say anything in Article 2 about executive discretion. There's a certain irony in that Marshall can't embed some notion of judicial review that's not written in the Constitution but implied And yet Jefferson uses this notion of executive discretion as his primary argument. So it's a little bit of a hypocritical argument on Jefferson's part.
No question. We need to take another break. Talking with my friend Beau Breslin of Skidmore College, always such a delight. This is Marbury v. Madison 101. Much more to talk about. We'll be back in just a minute. You're listening to the Thomas Jefferson Hour. Welcome back to this special edition of the Thomas Jefferson Hour. Seated across from me, at least virtually, is Beau Breslin of Skidmore College. First of all, you said seriatim decision, so nobody really said how the court should decide stuff. There was a tradition that different members of the court would write different decisions based upon what they had heard, and that's kind of returned today. We get a lot of dissenting and concurring decisions today. Marshall wanted there to be a unanimous or a consensus statement on things, and so he managed to get that done. Jefferson believed that Marshall was a loose, lounging, tavern-seeking sort of guy who liked to have a glass of ale with common people in taverns, and that, for Jefferson, that somehow discredited his cousin. And he also knew that Marshall used to call these breaks in the afternoon when the court was sitting and pour wine on the kind of the principle it must be 5 o'clock somewhere, and that he was seducing these other justices. Pretty ironic given Jefferson's hospitality habits in the White House, but Jefferson felt that Marshall had undue influence over the others because of his strength of character and personality, but also because he was sort of flattering them a little with wine, and that he should be a justice with a kind of a remote judicial temperament. And Marshall looked on Jefferson as just kind of a loon, I think. And I think what drove Jefferson nuts about Marshall is that he was a Virginia Federalist, and Jefferson believed there cannot be a Virginia Federalist. If you're a Virginian, you're not a Federalist. And so I think it actually just kind of enraged him that Marshall made the wrong basic choice in politics.
I think it's fair to say, you correct me if I'm wrong, Jefferson did not prioritize the kind of down and dirty politics that was starting to emerge at the time. Right? He's still trying to hold on to this notion of, some kind of civic honor and so on. Marshall was the great political strategist. And so I think one of the reasons why they didn't get along is because Marshall sees the world as kind of a political game that he's got to navigate. And Jefferson wanted to resist that as much as possible.
Jefferson spoke of Marshall's twistification. He's not really a small R Republican. He's a power guy, and that he twists the Constitution to get the results that he's looking for, but this is not a legitimate attempt to read authentically the intentions of the founders.
Jefferson pegs him exactly right in Marbury versus Madison. So some of the things that are fascinating about Marbury versus Madison is that it's clear that Marshall specifically either ignored or misread parts of the Constitution and the Judiciary Act in order to get what he wanted. Article 3, Section 2.2, it reads, in all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction, right? So Marbury comes to the court, the Supreme Court, as a trial court. And Article 3, Section 2.2 of the Constitution says, in all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. So Marbury thinks this is right. And the answer is, for Marshall, there's no question that Madison is a public minister. Insofar as a public minister is someone who, quote, represents the United States at a foreign court, the Secretary of State, who's Madison, is arguably the chief public minister. Essentially, Marshall has to ignore that reality. And then the worst one, Clay, is when Marshall has to ignore the fact that the next sentence of the Constitution grants Congress exceptions to jurisdictional questions. Those exceptions were exercised in the Judiciary Act of 1789. Congress has the authority to grant exceptions, and Marshall specifically does not mention that part of the sentence in his opinion. He's manipulating, misreading deliberately the parts of the Article 3 in order to get the outcome, judicial review, that he wants to get.
So let's back up. 55 people meet in Philadelphia and produce the Constitution of the United States. Article 1 is about the legislative branch. Article 2 is about the executive branch. Article 3 is about the judiciary. The Constitution is only 4,500 or so words long. It's a very general and in some ways vague document. And so once it has been ratified in 1788, now Congress has to go in and fill some of these gaps and create the kind of infrastructure, the kind of scaffolding to make these three branches work, and particularly the judiciary. So the Judiciary Act of 1789 could almost be called an addendum to the Constitution of the United States. It's trying to figure out now what, how do we populate this Article 3 branch? And I would say that it's a largely nonpartisan document. It's a structural document. But then Jefferson supplants John Adams to become the third president, and in its last days, the outgoing Congress of the United States passes the Judiciary Act of 1801, which is certainly a political document. It's not solely a political document, but it's mostly one, and it's designed to deny Jefferson a chance to appoint people to the court. It relieves the justices of circuit riding, which they hated. It creates a bunch of new judgeships and so on. So when Jefferson sees this, he realizes that it was a political act, not a statesmanship act. And so he decides he's going to chasten the court. So a couple of things happen. First of all, he starts off by denying Marbury and the others their commissions. So that's a political act of rebuke. Then he has the Judiciary Act of 1802 passed, which undoes a lot of the things in the Judiciary Act of 1801, raises the number of justices, puts them back on the circuit riding, maybe just to annoy them. And so this is a political response. As if that's not enough, he goes after some members of the Article 3 branch. This is all a political set of maneuvers. You can't call this high-minded Platonic statesmanship. This is they're knuckling it out over Article 3. So today when we say, oh, the court is becoming politicized, we're ignoring the incredible political history of the court.
The politicization of the court was more significant and a bigger part of the American political experiment in 1800 and 1801 and 1802 than it is even now. It's hard to imagine.
If Jefferson had gotten away with what appears to be a vendetta, this could have really damaged our capacity to be a stable republic. Today we think we must not politicize certain things. And when they do get politicized, we all worry about whether we're going to survive as a republic. I have to say, and I hate to say it, but I think that most of the virtue is on the side of the Federalists in this quarrel. They had a right to create the Judiciary Act of 1801. Jefferson probably shouldn't have tried to eliminate those courtships. Riding circuit's another question. But on the other hand, the Judiciary Act of 1801 by the Federalists should not have attempted to limit the number of appointments that Jefferson could make. So they're both behaving pretty badly here, Beau, but they're playing with fire, it seems to me. And one of the things I give Marshall credit for is bringing long-term stability and credibility to the Supreme Court of the United States.
Agreed, and I think the fact that Jefferson essentially won the case, Madison wins the case. I think that helped ease the tension at the time, despite the fact that judicial review was established. I'm curious as to whether Jefferson ever thought, after Marbury versus Madison, other branches could rule congressional law unconstitutional, because although Marshall says it is emphatically the province and duty of the court to say what the law to say what the law is, it's not like he drops the mic in that moment. It could have been a situation in which Jefferson's like, okay, yep, sure, but we're also in the executive branch going to also decide the constitutionality of legislation.
Jefferson did have some commitment to what you said. So when he becomes president, he pardons the people who had been jailed under the Sedition Act, and he remits their fines because he said these are palpably unconstitutional laws that were passed. And so he's exercising what he takes to be presidential prerogative of vetoing unconstitutional legislation. He also said something really interesting that I bring up whenever there's a Supreme Court hearing in the Senate. I think that one of the most shameful things in American public life is a Senate hearing of a Supreme Court justice. It's really low theater.
We've never been able to get back to a time when competence was the standard that we strove for in our Supreme Court appointments.
I agree with you 100%. So back to Marshall for a moment. Marshall has an idea about America, and that is that the Supreme Court, the judicial branch, should be co-equal if possible, and he accomplishes that, I think. He certainly moves down that path. But more importantly, he believes that the national government, the central national government, should be supreme, and that the idea that this will be kind of a shared sovereignty situation, a federalist situation, is problematic. And so all of his decisions, Cohen's, McCulloch, and others, move towards a stronger central government and a weakening of state sovereignty. That's a vision or a sense that he has, which is respectable. Should one very strong member of the court have that kind of power to turn the constitutional settlement as strongly as he did towards national centrality?
No, he's he's first among equals as Chief Justice. He's one of 6 at the time. Does it happen? Yes, and I think what we would describe as the modern version of John Marshall is Earl Warren, right? So there's no question that during Warren's from 1953 to 1969, this rights revolution is driven in large part by, this would be a fascinating, especially if you're in Listening to America, a fascinating episode is think about the ways in which Earl Warren was both politically masterful in getting the court to move in particular directions. He had some help, there's no question about it. He has quite a liberal court, but Brown versus Board of Education is, a fascinating case study in his ability to maneuver and convince and persuade in the same way that Marshall is able to do it on federalism. Warren is able to do it in civil rights and civil liberties.
We just have a few minutes left. I want to ask you what you're reading here in a minute and what we should read about this subject. But going back to riding circuit, so I hope everyone understands that one of the things in the Judiciary Act of 1789 was that these Supreme Court justices needed to travel to the outlying areas of the country and handle cases personally from time to time. Partly this was a cost-saving thing, but it was also to keep them honest, keep them with the people, to keep them embedded in the real communities of the United States, to hear actual cases and not just cases that burbled up through the lower courts. They hated it, of course, because there were no hotels and the roads were terrible, and they hated to travel in this way, and so on and so forth. So Jefferson then, I think mostly in a punitive way in the Judiciary Act of 1802, forces them back into riding circuit. And the irony is, of course, that in 1807, Marshall is riding circuit in Richmond when Jefferson's nemesis, Aaron Burr, is tried for treason. And so the two of them play out yet another drama, because here again, Marshall mostly gets the best of Jefferson, but not entirely. So Marshall says that Jefferson should be subpoenaed to come and make the case for the government. Jefferson, of course, refuses. He asserts executive immunity and executive privilege, but he does compromise and agree to send many of the documents that Marshall wants. Marshall then has dinner with Aaron Burr a couple of times in Richmond, and then sides sort of in the middle. He says that Burr is not guilty because not proved guilty. He doesn't acquit him, but he doesn't convict him. And so here they go again, these two mighty figures of Virginia.
Yeah, it's just fascinating to think about the interrelationship of all those Virginians, right? They were a powerful lot, and I think we underestimate exactly how successfully Virginia, for lack of a better term, bred some of the greatest thinkers of the 18th and early 19th century. And so it is a fascinating sort of interconnection among power brokers.
And one more thing, Marshall detesting Jefferson for all the reasons that he did, writes a massive 5-volume biography of George Washington, in which he belittles Jefferson's contributions to the American Revolution, ignores Jefferson and Jefferson's people, creates what Jefferson thought was a hagiography to General Washington. John Adams hated it too and said it was a 5-volume mausoleum. So that Marshall helps to create the historiography of the Washington administration and the Federalist Party. And Jefferson spends the rest of his life trying to find somebody who will write a counter history. Thought of doing it himself, but he didn't. But here Marshall wins again by writing this extraordinary encomium to the brilliance of George Washington as against these crazy Jeffersonians.
Yeah, and as I guess if you spent any time with Washington and Valley Forge, you got an inflated view, not an unreasonably inflated, but Washington appropriately becomes your hero. So yes, Marshall is is a fan of General Washington.
So what should we read on this subject? We're not going to law school.
Yeah, so I know we're used to thinking about contemporary biographies and things that are happening, but I'm going to draw your attention to one that was written, I think, 70 years ago. Albert Beveridge has a 4-volume biography of John Marshall that is
4 volumes.
4 volumes that is well worth picking up. The Marbury versus Madison is in volume 2. If you want to go directly to it, but it's a wonderful detailed history of Marshall's life from beginning to end. So if I had, go to the library and pick out Albert Beveridge's 4-volume set and, maybe pick up one of them. Marshall has a fascinating life outside of Marbury versus Madison. And so I would encourage your listeners to go there.
He has a fragile wife who suffers from mental instability. He turns out to be a marvelous husband and very carefully protects her through life. I'll give our listeners a break here, Beau. 4 volumes by Beveridge. Are you nuts? I say James F. Simon's book, What Kind of Nation? Thomas Jefferson, John Marshall, and the Epic Struggle to Create the United States. That's one slender volume of a couple of hundred pages. James Simon, What Kind of Nation? Thomas Jefferson, John Marshall, and the Epic. What else are you reading? What are you reading that's not in about this?
Oh, I like, there's a book that I'm reading. I'll take it off my shelf. John Finn's Peopling the Constitution. John Finn is he's not a retired political constitutional scholar from Wesleyan, and he's a constitutional theorist. So he argues about various things related to constitutions and how the U.S. Constitution shaped the people and how the people shaped the Constitution. Fascinating piece of work. So if I could have one book that I mention on, I would do John Finn's Peopling the Constitution. Peopling
the Constitution, John Finn. Well, we got to leave it at that. Come back in a few weeks. We'll find another subject here. I so enjoy our conversations. Everyone, stay tuned. We'll see you next week for another important edition of the Thomas Jefferson Hour.
The Thomas Jefferson Hour is brought to you each week by Dakota Sky Education. The program is distributed nationally by Prairie Public. President Thomas Jefferson lived from 1743 to 1826, and this program presents his views. President Jefferson is portrayed by the award-winning humanities scholar and author Clay S. Jenkinson. This program is also available online at jeffersonhour.com and on Apple Podcasts. If you'd like to correspond with President Jefferson or submit a question for him to answer on the program, please visit the website at jeffersonhour.com. Bach Cello Suite No. 3 in C Major by Stephen Swinford. Thank you for listening. Please tune in again next week for another thought-provoking, historically accurate program through the eyes of Thomas Jefferson.